In this video, the public will see the real reason why Fort Collins Judge Brinegar ruled to suppress access to exact copies of unredacted digital records in the homicide of 19-year-old Jeremy Holmes. The Colorado Office of Attorney General represented Colorado State University in the Susan Holmes open records case. They were the opposing counsel. Judge Brinegar is the district judge who ruled against Susan Holmes and in favor of police secrecy. Body camera footage and audio files are digital records. Let me say that again. Body camera footage and audio files are digital records. The antiquated Colorado Criminal Justice Records Act, CCGRA, does not contain any criteria for authenticating digital records as exact copies. Therefore, police agencies can release or export altered video footage and audio to the public without any oversight. This happens all the time. When police alter video and audio files, they are committing an illegal act called tampering with evidence. Okay, here is a copy of the order and judgment in the Susan Holmes versus Colorado State University open records case. Please note, date filed July 26, 2019. Notice the timestamp. Okay? I want people to be aware that timestamps are the basis for all records in the judicial and criminal system. You need timestamps for verification of anything. And that is when I got a copy of the ruling. Right? So I'm going to scroll through this and I'm going to show the public the key statement, the key lie that Judge Brinegar, who ruled in this case, applied to the determination that Susan Holmes, myself, should not have access to criminal justice records, i.e. the body camera footage and audios, the unredacted, timestamp, keyword timestamp, independent, raw data, digital records. Those are all key words for people to understand that Susan Holmes kept requesting. That's me, myself. So I'm scrolling down and you can see it buried in the analysis with lots of sentences beforehand and sentences afterwards. A key piece of really good propaganda that the judge put in the middle of all this, buried in the middle of it. But this piece here shows and implies something very significant in this case. I consider it the key sentence for why she was able to deny access to the body camera footage copies, exact copies, and the audio, time-stamped exact copies. Now, I'm using the words exact copies, time-stamped, because once again, these are very important legal terms. When you go to a court, or when you go to a police station, or when you go to a DA's office and you need to get copies, legal copies, they have to be time-stamped. They have to be original copies. They can't be copies where they deleted sentences out of them. Okay? You can't delete sentences out of records, paper records. Now, in this case, I'm talking about digital records. And the judge is trying to apply the CCGRA, which you see up here, the Colorado Criminal Justice Act. She wants to limit it to that act in determining why she would deny me access to the records. However, it doesn't even apply. she didn't have to utilize that because she kept stating the viewing. You see viewing everywhere throughout this document, and I'll provide the link for it. But you'll see she keeps referring to viewing. She intentionally ignored the fact that I asked for copies of the digital records. This is a key important legal statement. Copies, exact copies of the digital records. So when you go to a court, like I was just saying a few seconds ago, when you go to a court or a police station or anything, you get exact copies. They can't pull out a paragraph and tell you this is an exact copy. They would be fined or they would be fired for doing that, okay, in any records department. They have to give you an exact copy. Now, they might redact it where they black out certain things, but it has to be an exact copy. I will get into that a little later here about what an exact copy is for a digital record, because the Colorado Criminal Justice Act has absolutely no criteria for what an exact copy of a digital record is. And what does that mean to the public? That means the police can issue all kinds of digital records that are fake because they have no standard. There is absolutely no state standard for measuring an exact copy of a digital record, a body camera footage, or an audio file. It doesn't exist in the Criminal Justice Record Act, but the judge wants you to, she doesn't want you to know that. I provided it in my briefs in this case. She knows that. That was evidence. I provided the exact federal law that provides an example. Not only an example, but it provides law and what law is in determining the criteria for authenticating digital records. Exact copies. But she doesn't want to tell you that. She doesn't remember. She doesn't want you to know I'm asking for exact copies of digital records. So, let's get to this sentence, which is I consider key, and it's a lie. Because, by implication, by omission, and directly. The court did hear testimony by plaintiff that, in her opinion, tampering had occurred to the video and audio recordings. However, the court finds there is no credible evidence to show any tampering occurred. Now, why would the judge make that statement? Well, she is acknowledging the only time any of my evidence or any of my testimony throughout the case. One piece here, but it's in order to deny it, to deny that I had no evidence, any credible evidence. So she not only says evidence, she says any credible evidence. And what does that do? It's meant to discredit my testimony through language. So when people read this, they immediately are not thinking, they're not thinking consciously, but it goes in, no credible evidence. Oh, okay, well, the court must be right. The plaintiff never provided any credible evidence to show any tampering occurred. But here's the fact. Here's what the judge doesn't tell you. That in order to prove that tampering occurred, Susan Holmes, myself, the plaintiff, needed access to the police records, the unredacted records, and audio files, time-stamped, independently raw data, so that she could take them to an independent crime lab and have a forensic analysis done and be able to authenticate whether the video and audio recordings had been altered or tampered with. The judge knows this because I provided this information in the briefs. But she never refers to those briefs. What she says is that there was no credible evidence to show for tampering. She also wants you to believe by implication that I needed to provide evidence to show there was any tampering in order to get access to the very records that I would need to prove that. You see the double bind in this? It's intentional. Oh, she didn't provide any evidence, credible evidence to show tampering. So therefore, hey, she doesn't need access to these records. But once again, that's a very twisted, false implication, because that is why this court case happened, is I needed records. I needed the copies, exact copies of the digital records so I could prove the tampering, because I know it was tampered with. However, let me state again, she said there was no credible evidence. However, I did provide some credible evidence of the audio files being tampered with. Okay, in the prior document, which was the judgment by Judge Brinegar in the open records case, she stated that there was no credible evidence the plaintiff provided. I also talked about timestamps, key words, but she stated that the plaintiff provided no credible evidence. So I now have you focused on this brief right here. And if you notice, this is a brief, and it's dated, I can show you right here, responsive brief. It's filed by Susan Holmes, the plaintiff. There's Susan Holmes, Colorado State University. The file date was July 3rd, 2019. This is during the court case, the open records court case with Judge Brinegar. Here's the responsive brief. I'm going to scroll down. All right? So remember, I'm taking you down, and by the way, this link will be provided below so people can read it. But this is also a scanned document. After it was time-stamped up here by the court, I then took it and scanned it so that I could upload it to the website. And the scan is a little crude, it's a little scratchy at times. And it doesn't show the color that was supplied in the original filing. But I'm going to show you that. I just wanted to let you know because I'm going to show you a document, the same exact document, but more clear once I get into this. So, the judge says the plaintiff never provides any credible evidence of tampering. Well, I want you to look at this document here. Plaintiff provides metadata analysis of the 3 audio files. Scroll down. There's a 4th audio file that was added as a control to be able to compare what a real audio file looks like that hasn't been tampered with. But I'm going to show you a clearer image in just a second. Let's scroll down. This is the documents. This is the one that had the timestamp on it, this document. Scroll down a little bit here. Screenshots of the metadata in the detail tab from audio 1, 2, and 3, and a personal audio file from the plaintiff provide evidence that the CSUPD audio files are not copies, exact copies. All right? This lack of data indicates that the files have been altered, edited, and compiled from pieces of conversations. None of these files were accurate reproductions of original calls. These files demonstrate that CSUPD is tampering with evidence. Copies of these files were included with a crime report submitted to the FBI by the plaintiff. And then I go down here in my brief to outline the federal rule that oversees and defines what data copied from electronic device or file and how it's supposed to be authenticated by a process of digital identification. And it's called authentication. So you can see as I scroll down this brief, I provide all kinds of evidence here. Specifically that the files given to me by the opposing party were spliced together. As soon as they sent them to me, I rejected them. I testified to that because I would not accept spliced files because I knew they were not exact copies. For something to be a legal document, digital legal document, it has to be an exact copy with a timestamp and a date on it. These were not exact copies. Okay? And I put that right inside the brief. All right? Now, let me show you a clearer version right here. This is the version that the court saw. Same exact document, just in color. I want to show you here the detail tabs, detail tab, detail tab, detail tab on 4 different files. Audio 2, Audio 1, and Audio 3 were the files that were supplied by the opposing party, the attorney generals, who were attorney generals from, they were the counsel against Susan Holmes, myself. They supplied these files to me, hoping I would accept them, and I rejected them. Okay, now if you look at this audio over here to the left, this is what an audio with metadata looks like. It has a timestamp, November 27th. It has numbers. It has names on it. If you look at the audio 3 over here to the right, nothing, no metadata of any kind. If you look up at audio 1 and audio 2, which came from the opposing parties, no metadata, no timestamp. All these files were spliced together. These files were submitted to the court as evidence that they were not exact copies. The CSUPD audio files are not exact copies. That's why they were rejected. They were spliced together, which is evidence that they alter audio files. These files demonstrate that CSUPD is tampering with evidence. The link to this brief will be provided below. But when the judge says that the plaintiff never provided credible evidence, well, the judge lied. Because there it is, date filed July 3rd. There was credible evidence that CSUPD altered audio files and spliced them together and tampered with the evidence. That's evidence. The judge lied in a judicial document. One other point that's very important for people to understand is that the opposing party's attorney, the opposing party, Colorado State University, their attorneys never had any complaint about this information. They never filed any document stating that this wasn't true. They accepted this brief. They never had any opposing opinions to this evidence that was provided to Judge Brinegar.